Thank you, everybody, for joining our first webinar of fiscal year 2013. This is Lauren Christopher from the Administration for Children and Families, and I'm joined by staff today as well as our contractor, NIHEAP, the National Energy Assistance Directors Association, and several speakers. I want to thank, in particular, Mark Wolf and Cassandra Lovejoy, who have worked on this contract and getting this webinar series up and running for us this year. This is the first of 4 webinars that we'll be conducting in partnership with NIHEAP. The topic today is on vendor agreements, why they're important, and key aspects to keep in mind regarding negotiating these agreements with your utility vendors. And so on behalf of ACF, again, I just want to thank NIHEAP for organizing this webinar and for all of you for participating today, and we look forward to a lively discussion. And without further ado, I will turn it over to Mark Wolf.
Thank you, Lauren. On behalf of NIHEAP, clearly we really appreciate the opportunity to be able to organize today's webinar. A couple ground rules. Appreciate if everyone could hold their questions till the end and submit them online. We'll then address the questions at the end of the session. I'd like to go ahead and introduce our panelists. Elizabeth Bellis is our first speaker. She's the director of the Energy Program Consortium's Qualified Energy Conservation Bond Project and works on various energy finance programs with a special interest in tax. She previously worked in the tax department of Delavoye and Plimpton, a New York law firm, and specialized in bonds and capital markets. She holds a degree from the University of Chicago as well as the Harvard Law School. Kay Joslin will be an additional speaker since 1999. She's been the director of the National Center for Appropriate Technologies LIHEAP Clearinghouse. Kay is responsible for overseeing the development, maintenance, and dissemination of information on the LIHEAP program and low-income energy programs nationwide. Since 1993, she has been on the board of directors of the National Low-Income Energy Consortium and is an active in planning for the National Energy Utility Affordability Conference. She'll be joined by Nick Sunday, who previously served as the chief of the Office of Community Services in Ohio from 2003 to 2012. In that role, Nick worked closely with Ohio's community action agencies, other nonprofits, in addition to over 2,000 utility vendors in the state to provide energy assistance to more than 500,000 low-income families throughout Ohio. Nick has more than 32 years of experience in dealing with federal and state policy issues relating to energy assistance and the Community Services Block Grant. Jim Nolan is our other speaker today. He has experience with LIHEAP starting back at the beginning of the program in 1981. He was one of NIHEAP's founding members and served 2 terms as its president. As Montana's LIHEAP director, he represented the program's interests to the legislature and the state's Public Utility Regulatory Commission. He was twice appointed by the Secretary of Energy to terms on the Department of Energy State Energy Advisory Board, a congressionally mandated council to aid the Department of Energy in delivering energy efficiency programs. He recently retired from state government and is now a senior NIHEAP advisor. With that, I'll turn the session over to our first speaker, Elizabeth Bellis.
Thank you very much, Mark. Before we get started, I'd just like to start with a quick disclaimer. Although I am an attorney and this presentation does include some legally related content, this presentation is really intended to serve as a general introduction to vendor agreements, and it shouldn't be construed as or relied on as legal advice. So getting started with the purpose of vendor agreements, let's talk a little bit about why we have vendor agreements and what purposes they serve. As many of you may know, the LIHEAP statute requires that each participating grantee establish procedures to accomplish a number of policy and regulatory goals. These provisions are often included in vendor agreements, and they include notification of participating households about the amount of funds being paid on its behalf, assuring that the home energy supplier will charge that household the right amount, that is, the difference between the actual cost of the home energy and the amount of payment made by the grantee on the household's behalf. Assuring that the vendor will treat LIHEAP households the same as other customers, and ensuring that vendor payments are made contingent on vendors taking certain measures to alleviate client energy burden. The vendor agreements are a way to facilitate agreement between vendors and clients in the case of unregulated vendors, specifically to reduce home energy costs, minimize the risk of home energy crisis, and encourage regular payments by the households or individuals receiving LIHEAP funds for home energy costs. Agreements with regulated vendors contain similar provisions, and we'll discuss some of the differences when we go to the specific provisions. For more information, you'll also be able to see our checklist with information about each type of contract. Programs that meet these requirements described above include budget billing or payment plans, which encourage regular payments by LIHEAP fund recipients, shut-off moratoria, vendor discounts or other rate assistance programs, which can reduce home energy costs, and emergency delivery procedures to minimize the risk of home energy crisis. Vendor agreements have value in a number of different ways. Firstly, a good vendor agreement serves as a legal contract that can be enforced in court if necessary. But the value of a vendor agreement goes beyond this. The very process of agreeing to a set of terms provides an ally for both parties to get on the same page about how the relationship is going to work, and in some cases to bargain in advance about important terms such as costs or other matters that may otherwise be subject to dispute. The vendor agreement also is valuable in that it provides written documentation or evidence of the agreement that has been reached. So in the case that the parties may have forgotten what they had agreed to or have different recollections or be confused, the vendor agreement provides a kind of a neutral source to go to check back and see what did we agree on exactly, what did we promise, who's responsible here, and that can be helpful to avoid having to go to court to deal with a dispute. Vendor agreements cover quite a range of different types of vendors that we're going to cover here on slide 6, from regulated natural gas and electric utilities to unregulated gas and electric companies such as municipal utilities and co-ops, to unregulated fuel dealers such as sellers of heating oil, propane, kerosene, wood, and the like. Now, grantees or local administrating agencies are also parties to the agreement. Clients, however, are generally beneficiaries rather than direct parties to these agreements. So we mentioned that a vendor agreement, a good vendor agreement, is a legal contract, but what does that really mean? Well, a contract is an agreement between two or more parties that may be enforced by governmental authority if broken. So the first point there is it's pretty difficult to get a contract with only one party. There are some rare examples of unilateral contracts, but for the most part, you do need two parties agreeing. And secondly, it's an agreement that the government is willing to enforce if broken. Not all agreements are enforceable. In some cases, they might violate public policy, or there may be other reasons why courts will refuse to enforce them. So a good contract doesn't violate any of these rules. Secondly, a contract is a good way to comply with the LIHEAP statutory requirement that the grantee establish procedures to assure that vendors act or refrain from acting in specific ways, as we've discussed in the previous slides. Now, it's important to note that each state has its own rules about contract law, and that the rules regarding severability, liability, enforceability, damages, and really many of the critical elements of contract law can vary. But there are some general requirements shared by most jurisdictions. Before we talk about those, it's important to note that because of this variety in contract law state to state, it's very important when crafting your agreement to make sure that it is reviewed by counsel familiar with the law of the state under which it will be interpreted. So even if you've gotten a provision from another state agreement that has been used for years without difficulty, it's important to make sure that it will be interpreted the way you want it to be in your state under your state laws. So what are the basic elements of a contract? What makes an agreement an enforceable contract that courts will respect? Well, we talked about the fact that we generally need at least two parties. It also involves an exchange. One party will make a promise to the other in exchange for one of a number of different responses from the other party. So the other party might agree to do something, or not do something, or just act in a certain way. So, for example, a grantee may agree to provide or promise to provide LIHEAP funds in exchange for a home energy supplier charging the right price. Similarly, the grantee might agree to provide LIHEAP funds in exchange for the home energy supplier not adversely treating a household that receives LIHEAP funds. On the next slide, we have an example here of a vendor agreement checklist that we have developed to assist grantees in developing and reviewing vendor agreements. Now, Kay, Jocelyn, and I will be going through some of the most important provisions of this checklist during the presentation, but the full checklist will be available for download from the LIHEAP website. Coming back to contractual provisions, there are some contractual provisions that are so general that we haven't necessarily included all of them in the checklist, but it's important to think of them as a framework for understanding your contract as a starting point. First, it's important that your vendor agreement contracts specify the parties that are actually exchanging promises. In particular, it's important to get the correct legal name of each party involved, the full and complete legal name. Your contract also should specify the promises that you're making and exchanging with the other parties. So what is each party going to do or refrain from doing, and when is that supposed to happen? Your contract should specify how long it will be in effect. Is it a one-year contract, a multi-year contract? Does it have certain automatic renewal provisions, perhaps? Your contract should also specify the law under which the parties want the agreement to be interpreted, and this goes back to what we said before about different states, in some cases, interpreting the same language differently. Contracts usually contain some what we call representations, and what that really means is these are facts that the parties are each promising to the other that are true. So an example might be you might require that the vendor represent that it is duly licensed in your state. Conditions are a little bit beyond representations. These are circumstances or conditions that must be in place for the agreement to be binding. So again, you might make it a condition of the agreement that the vendor be licensed in your state. If it turns out that the vendor is not licensed to operate, or for example, maybe has litigation pending against it, you might say that your agreement would not be binding in those circumstances and you would not be required to pay them and continue the agreement until that was settled. Another general contract provision has to do with notices. There are a number of circumstances in which one party might need to contact the other party about something relating to the contract. For example, if the grantee or local administering agency believes there's been a default or a breach or some other problem in the execution of the contract, in some cases that party will want to notify the vendor that there's a problem. And it's important to know where to send that notice and make sure that the energy supplier will actually receive it so that it can respond accordingly. And so that is a general provision that's often in contracts, including vendor agreements. And finally, and we'll talk about this a little bit more in depth as we go through, remedies for breach is a provision that may be in a general contract. And this relates to what happens if a party breaks a promise in the contract. What if a party doesn't do what they said they would do? And we'll talk a little bit more in depth. But now I'm going to turn it over to Kay Jocelyn to talk a little bit more in detail about some of these provisions.
Thank you, Elizabeth. What I'll be talking about is specific features and trends that we at the LIHEAP Clearinghouse have seen when we're reviewing these vendor agreements. And the way we review them is we've had access over the years to these agreements by reviewing state LIHEAP plans. As you know, in filling out your plans each year, there's a question in the annual plan that says, how do you ensure that the vendor has complied with the requirements of the law? It asks you how to do this, as well as attach your vendor agreement. So as a result, we've seen and reviewed agreements from at least 32 states. And just because we haven't seen all of them doesn't mean that states haven't submitted them. It just means that they weren't included with the state plans. And so what we've seen is a lot of variation in these vendor agreements. Some are very short, about 2 pages maximum. Some are very long and detailed with features and regulations specific to each state or tribe. This reflects the flexibility that grantees have to structure and negotiate these vendor agreements to fit their programs as needed and to offer benefits and protections to the grantees, the vendors, and the clients. The very first protections I'll be talking about is protections to the grantees, which kind of essentially ensure and enhance program integrity. And here are some ways that is done. The vendor agreement can specify how the LIHEAP benefit is to be applied. For example, only toward the current home energy bills, or maybe to include past due bills or other vendor charges. The agreement can specify what payments are allowable and what payments are not. It can ensure that all payments are timely and properly allocated and verified. It can require proper record keeping on the part of the vendors and proper reporting for performance measures and audits. And the performance measure piece is particularly important now that there are going to be expanded new requirements for reporting under performance measurements. Vendor agreements can also help establish the vendor's identity and legitimacy as a business. And some of you may remember the GAO report of June 2010. One thing that the GAO found was that they created a simulated vendor company and were able to get LIHEAP payments and LIHEAP clients, and then, so they therefore concluded that there were not a lot of controls on establishment of vendor's identity. Vendor agreements can also provide a method for refund of unspent LIHEAP funds or credit balances, for example, if a client moves or dies. And they can provide recourse for inaccurate or fraudulent acts by a contracted vendor. And there are also, in well-constructed vendor agreements, there are very important protections for clients that can be built in. And at the clearinghouse, we get a lot of questions on this topic, especially from people in the advocacy community. And their overall concern in this area is how can vendor agreements be structured to better protect the clients? Some examples are the grantee can include in the agreement that the vendor must meet requirements for special provisions such as enrolling clients into any low-income discounts they have, or not shutting them off during a moratorium period. The agreement can require the vendor to adhere to emergency fuel delivery procedures to prevent or reduce crisis. For example, make sure that the vendor will deliver after hours or deliver up to a certain amount of the LIHEAP benefit, even though that may not be enough for a full tank. Vendors must agree or can be made to follow procedures and policies regarding shutoff prohibitions and requirements for reconnection or continuation of service. They must also follow federal anti-discrimination policies and other applicable state or federal law, and they must ensure confidentiality of client information. Additionally, vendors may be required or encouraged to offer payment plans so that the client can make an affordable payment each month, and this helps to prevent or reduce crisis. Vendor agreements can include additional client health and safety requirements, such as the vendor will agree to report if he sees something out of place at a household or nobody's home for a while. Also, they can include procedures for payment in the event vendors refuse to serve a client. In that case, they can be required to notify the local agency, in which case the agency may decide to issue the benefit directly to the client. So overall, what we see here is kind of a bigger picture. In general, with a properly designed vendor agreement, there are 3 mutual benefits for all parties concerned. The first mutual benefit is increased LIHEAP purchasing power. And what we mean by this is because grantees, as I mentioned, can go through the vendor agreements and require vendors to enroll clients in a discount or not charge a specific fee or provide a reduction in heating oil costs, that means the grantee is purchasing energy for a lower price than it would have otherwise, therefore stretching LIHEAP dollars, getting more bang for the buck, which means there's more available money to serve all the clients, to serve more households. The second mutual benefit to everybody is reduced crisis caseloads. And as I mentioned before, we've seen a lot of protections in these vendor agreements for clients, especially when the clients are facing an energy crisis, such as a pending disconnect or an actual disconnect, or they're either out of money or close to out of fuel or close to running out of fuel. Grantees can reduce crisis caseloads by requiring, for example, that the vendor deliver after hours, accept a phone, fax, or email guarantee of payment, or accept notification from the agency that the client is eligible as a requirement to continue or reconnect service. And the result of all this is reduced crisis applications. And as you probably know, responding to crisis situations can be the most labor-intensive and costly part of running LIHEAP. And that's true for the vendors as well, because it is costly for them to disconnect and reconnect households or to do emergency fuel delivers. So if you can reduce crisis caseloads, therefore you save money, which brings us to the third mutual benefit, which is reduced administrative and program costs. Next, I want to touch upon vendor incentives. As we mentioned before, it's all about negotiating. And one thing that grantees can stress when they sit down with vendors is they will be providing a timely payment schedule and thereby assuring a more reliable cash flow for the vendors. For example, in Illinois, agencies must notify vendors who are to receive funds on behalf of the clients, and this has to be timely. For example, within 30 days of when they get a computer-generated form. In Massachusetts, for example, the agencies are required to mail payment of the invoice to the vendor within 30 days of receipt of the invoice. Grantees can also stress to vendors during negotiations that this participating in LIHEAP and having an agreement can result in a larger and more reliable customer base. Vendor agreements can allow for a better working relationship between local agencies and vendors. And the establishment of clear fiscal controls in writing and provision of oversight helps prevent not only customer fraud, but also possible theft or misdirection of LIHEAP funds by the vendor's employees. And finally, vendor agreements can be used to help promote a vendor's energy conservation and payment management programs. A couple final things about vendor agreements. They can be by vendor or vendor type. For example, some states will have one vendor agreement for their regulated utilities and another for their delivered fuel vendors. Some states have multiple delivered fuels. For example, Massachusetts has propane, kerosene, heating oil, and I believe corn for pellet stoves. The agreements can be 1 year or multiple years. They can be set up to be automatically renewed, or they can be renegotiated each year. That's some very general language there. So I'm going to turn this over to Nick and Jim from Ohio and Montana so they can discuss these negotiations a little bit more specifically. Nick?
Thank you, Kay. In Ohio, we negotiated contracts or agreements every 3 years. Obviously, with any new vendors or mergers, we would, start the contract at that year for year one. We two different types of agreements, one for regulated utilities and one for deliverable fuels. Each of the agreements had all the compliance issues, but with the regulated utilities, we mandated a monthly built-in data section where we were capturing really client-based information, and we did this for the purpose of the performance-based system going forward with LIHEAP. And we produced a file layout, and I'm going to bring that to share with some of the other states in San Diego. But the reason we did that is because a lot of the investor-owned vendors that operate in multiple states, and they do, if one state and one company can do it, the other companies can do it. So once it's been developed by the company, there's no associated cost for that company to develop this file layout. So I think that is a key going forward, especially capturing customer data for usage, payment history, anything that we need to know about these customers. And then now I'll turn it over to Jim from Montana.
Mm-hmm. Thank you, Nick. Just a couple of points about our negotiations with the vendors. One, as you see the bullet point there, is we used to use in the early years of the program a year-to-year contract. I think that was for a number of reasons, one of which people weren't too certain how long the program would last. So both from the vendor's standpoint and from our department standpoint, we thought going on a year-to-year basis would be the preferred way to go. But once it became apparent that this program had support in Congress and within various administrations, we did get permission to go to a multi-year agreement, which really simplified things. Instead of trying to track down contracts every 12 months, and I'm sure most of you know the problems that can be inherent with that, we did go to a 7-year agreement because so little seemed to change from year to year. It was strictly the dollar amounts. And once we outlined the parameters of the program with the vendors and with our local agencies, I think everybody was very satisfied that we actually went to a multi-year contract, and we have stayed that way probably for the last 20 years. And the other nice thing I liked about the going to the multi-year agreement is it really led us into to the modern era. Instead of mailing paper checks out to vendors, we began doing tape-to-tape transfers of funds and electronic transfers, which has really provided a very clean audit trail, both from our standpoint and from the vendor standpoint. So if anything, I would recommend that folks try to look at a multi-year contract with your local vendors. Elizabeth, I think I'm going to turn this over to you now.
Thank you. So let's talk a little bit about what happens if all of these agreements aren't actually met. Someone doesn't provide a payment within 30 days, for example, or someone doesn't provide a payment plan that they've agreed to provide. What can you do as a grantee in those situations? Well, it turns out there's quite a range of different remedies. First, there are some that you might think of as almost self-help type remedies that relate to whether or not you want to continue operating your program with the vendor in question. So, For example, in Oregon, the agency has a provision that allows it to give a home energy supplier 10 days notice that it believes that there's been a default or a breach of the contract. And then the home energy supplier has that 10 days in which it can correct the failures that are identified, or if not, then the agency can actually terminate all or part of the agreement. And depending on the nature of the default or the potential breach, the agency can choose to provide more than 10 days if it wishes to do so. But 10 days is sort of a minimum amount. And this is nice because it provides something of a formal procedure to begin the process if something goes wrong without having to go all the way directly to legal process. A related option is suspension. An example of suspension is here we have from the Connecticut Agreement, which provides that if a vendor isn't complying with all these terms and conditions in the contract, they can actually be suspended from the program for the remainder of the program year. That's a little different than termination because the vendor can actually come back after that program year if they get back into compliance. But it serves as something of a penalty to deter vendors from sort of negligent or needless failures to comply with the agreement. Now, moving on from these more self-help type of remedies, because these vendor agreements are legal contracts, there are also judicial remedies in the case of breach or failure to meet promises on either end. And the most common judicial remedy for breach of contract in the U.S. is money damages. So in that case, one party has broken its promise, and as a result, it is required to pay money compensation to the other party. And how much money is paid? Well, that depends on a number of factors, including state law. But in some cases, your agreement can actually specify the amount of money to be paid in certain types of defaults or breaches. These provisions are known as liquidated damages provisions, and many courts respect them. And that can be useful if you'd rather avoid a costly court battle and you have some sense of what is an appropriate penalty in the case of certain breaches. In rare cases where money damages aren't adequate, a court can command one or more of the parties to do what they agreed to do. So it's hard to think of too many examples where this might apply, but one might be if you're dealing with a rural service area and a vendor has agreed to serve that area and then decides after all that it doesn't want to serve that area anymore and there's no one else to provide service in a timely manner, and if this vendor doesn't comply with its agreement, the clients in that area will not have energy supply during that time. That might be an example where a court might be willing to require or command the vendor to do what it agreed to do. But in each of these cases, when you're talking about judicial remedies, your remedies are really limited by the cost of pursuing this kind of remedy. So if you're using outside counsel, the fees that are paid to attorneys, the time cost and delay of going through courts, even if you've got in-house counsel or governmental counsel, there are many different responsibilities generally for these counsel, and it can be difficult for them to pursue every minor breach of contract claim. And that's where some of the sort of self-help remedies discussed in the prior slide can be particularly helpful to avoid getting into this situation. Now, going beyond the judicial remedies for breach of contract, there are some breaches of contract that go beyond simply breaking a promise, but that are actually illegal per se. Even if there had not been a contract, this behavior would be unlawful, either because it is fraudulent or perhaps it is criminal. In those cases, you certainly don't need to specify in your agreement that you will prosecute your vendors or other parties for this type of behavior. However, many agreements do specify that, something as a warning to vendors that there are other rules that apply, that the contract is not the full scope of the relationship, and they are still bound by state and federal law as well. And in addition to prosecution, in some cases it may be appropriate to consider banning a vendor from participating in future state or federal contracting. Again, this is kind of a penalty provision, and in some cases it may well put the vendor out of business, which, depending on what the vendor has done, may in fact be highly appropriate. For an example of this, I'm going to turn it back over to Ohio to tell us about some experience they had with this.
Thank you, Elizabeth. Over the years, we really had mostly problems with unregulated delivery vendors, usually with hidden charges, scheduling routes outside of the normal route and everything. And these were really probably the most difficult ones to work with. The regulated vendors obviously are audited by the Public Utilities Commission of Ohio each year, and we would sample records on our own. One of the biggest items we had, and I think this started in New York, and it was a class action suit with 7 states against a major propane company for overcharging customers. The states involved in that, and I don't remember all 7, but I do know New York, Michigan, and Ohio were 3. Ohio received over $250,000 in illegal money that they overcharged, and they gave this to us in 2 installments. And in turn, we went back and placed that money back on actually the customer's account, working with the propane company very closely. Another item: if a vendor has breached a contract, we would first turn it over to our chief legal counsel, and then they would turn it over to the Attorney General for collection. There were 2 ways that they did this. The Attorney General had a threshold of mark of $1 mark that they would take the action themselves, or they would work with the county prosecutor to go forth with that vendor. And over the years, we had, I want to say, 2 vendors that actually committed fraud. They reimbursed the program, and then we actually disbarred them for any future contracts at the state and at the federal level. And Jim, I'll turn that over to you next in Montana.
Right. In Montana, we have used the vendor agreement since the beginning of the program. This has, as everyone knows, has always been an option, but we've always maintained that this was an excellent way to establish program integrity, and we have used it since day one. What we do is we have a number of monitors in the field, and when they go to do their monitoring of the local administering agencies, they will also pull a percentage of files from the local vendors, the propane dealers or the fuel oil dealers, and will actually go and do an on-site of those vendors to look at their LIHEAP clients to make sure that what our records show are reflected in the vendor's agreement, in the vendor's records. Occasionally they have found violations, but I will say to this date, we have not found anything of any major proportion. One of the reasons I believe that's the case is that Montana, although it's a large geographic state, is a small state population-wise. And I think that the tight vendor network, the word really gets out that the state of Montana is going to come and look at your records, so make sure they are kept up to date. So that has worked out well for us. The other thing that we've noticed as well is, in addition to when we visit the vendors to make sure that they're playing fair and square with the clients, the vendors have also alerted us to instances of what they have perceived as fraud on the part of clients, that they thought there were clients receiving LIHEAP help that probably should not have because they suspect that they have resources that they're not reporting to the state. So that has kind of worked as another provision that has helped us maintain the integrity of the program.
And I just want to conclude, I alluded to earlier that we had 2 types of agreements, one for investor-owned companies and one for deliverable. We enforce this in 2 ways. We did administrative reviews on deliverable fuels specifically, and third-party financial audits, both for the deliverable fuels and the regulated utilities. And this would be a random sample each year, so each company would not know who would be audited. Obviously, if there were issues or risk factors, we used a risk assessment. They could be audited each year. So the bottom line, it was to protect the customer and making sure that the proper benefits, met all the guidelines set up in our state plan.
There is a lot more information available on vendor agreements if you want to actually take a look at some of them and some other supplemental materials. On our LIHEAP Clearinghouse website, we present the latest LIHEAP state and tribal plans, and not every state and tribe has actual manuals that they make available, but a lot of them do. And some of these manuals can be very detailed. Like, for example, some of them will have a whole chapter on vendor issues and vendor payments and so on. Two that come to mind are Minnesota and Wisconsin, and there's probably others. And then, of course, as I mentioned before, in the state plan, usually the grantees, states and tribes, will attach their vendor agreement for the year. And then we have all of those posted separately, as many as we have, under a separate link on the website, vendor agreements. And one state in particular comes to mind, Alaska. They actually have a vendor manual written specifically for the vendors, which has a lot of just sort of play-by-play detail on what the vendors can expect, what they do in this situation and that. And it's pretty detailed. I think it's the only one I've seen. Doesn't mean it's the only one that's available, but it is geared to the vendors, and it's just called Alaska Vendor Manual. And should you have additional questions, you can direct them specifically to Cassandra Lovejoy at NIETA, and her email and phone number are on the slide. That concludes my presentation.
Well, thank you, Kay. This is Mark Wolf again, and now we'd like to turn to the questions that we've received from the audience, and we have 4 really good questions. So I'd like to start off with our first question for the panelists. Do any of the speakers have experience with vendors that were out of compliance, for example, with their vendor agreements? And if so, were any of these referred to your state attorney general's office?
Mark, this is Nick. Yes, with some of the deliverable fuel companies that were committing irregularities or fraud against the program, we would turn it over to the Attorney General, and usually there was a threshold that they set for getting involved, and that would be $500. Obviously, if they got involved, they took a fee out of that, but basically they were the ones that would handle the case to remedy the problem.
Okay, thank you. Jim, similar situation in Montana?
We've never had anything get to the Attorney General's level. Typically, when we raise the issue with a vendor, they have complied with our findings fairly quickly, and we've never had a case of having to even threaten to take them to court. So that has not come up.
Okay, thank you. Do any of the presenters have any experience with dispute resolution involving the vendor and the subrecipient? And following on that question, there was a similar issue about best practices to share when working on dispute resolution issues.
Well, this is Nick again, and one time we did have to kind of facilitate a meeting between a local community action agency and a local vendor. It was a delivery method that they were using that seemed unfair to the customer. A lot of the charges were going for delivery and not the fuel itself. So we actually had a meeting with the two parties, and this deliverable fuel vendor was a vendor who really operated in many states. So we did not get a lot of action from the local company. So we ended up calling the corporate headquarters, and once we told them how much money they received with LIHEAP each year, I think they realized, we were a big business partner with them, and they had the local company change their method and their billing method.
This issue really has not come up in Montana in terms of the vendor and the subrecipient. In almost all the cases, the state of Montana makes the payment to the vendor, and the subrecipients, if this is referring to the community action agencies, hasn't been involved, if that's what they're asking.
Okay. Another question that was raised about vendor agreements, one of the people that wrote in a question asked, when a vendor agreement lasts for several years, how do you ensure the LIHEAP client will remain eligible to receive funding for that period of time? So in other words, do you enter an agreement with the LIHEAP recipient to follow the length of time that the vendor agreement runs for?
Mm-hmm. At least in Montana, the vendor agreement is between us and the vendor. At the end of the year, any funds that are left are returned to the state. The client has to become eligible in each succeeding year. There's no claim that the client can make to that money in succeeding years. We close the program down every year, and any credit in excess of $50 must be returned to the state, and the whole program starts over the next year. The multi-year agreement just covers our relationship between the state of Montana and the vendor, and the client has to apply every year to maintain eligibility.
And I would agree with Jim. In Ohio, we our agreement is with the vendor, so it can span the 3 years, but each year a household has to do a yearly application, and we base the eligibility off that yearly application. And obviously, if there is any money left over, or the customer is moved out of the territory and there is a credit balance left, then there are procedures where the company would send that money back to the state to go back into the LIHEAP fund for the next year.
Okay, thank you. Our last question is if you can discuss the process for the development of vendor agreements. For example, after putting the initial agreement together, would you go through legal counsel before it goes to the vendor? And then is there a legal review process for modifying vendor agreements in your state?
This is Nick again. That is a very detailed procedure. Once we develop an agreement, whether it's the regulated or the deliverable fuel agreement, obviously all the criteria has to be in there on the discrimination and things that both Elizabeth and Kay referenced. But it goes through a process. It goes to our legal counsel. They would have to give approval, and once that is approved, the director of the department would sign off on it, and it would be the same way for any legal process for a modification, which has been kind of rare over the years. So once the agreement has been sanctioned by both the legal entity and the director, it's ready to go.
And I would second what Nick says. The considerations that Elizabeth and Kay laid out would be the framework for the development of our legal staff at the department level, taking those considerations and putting them into a framework that goes through the same type of review process that Nick talked about.
Okay, well, thank you, Jim. And I'd like to thank everyone for participating in today's webinar. I especially thank Lauren Christopher and her staff at the Administration for Children and Families, as well as our speakers, Elizabeth Bellis, Kate Joslin, Jim Nolan,